I'm so glad you could come back. My name is Kimmy Cummings, and I'm going to be dragging you through this bar prep. We're going to start off first with property. And for these videos, I am going to be the evil mistress of property for you. So first, we're going to talk about ownership of real property. Because in order for that property to be used, you have to own it. So who are the important people when it comes to ownership of property? Well, we have a grantor, who is the owner, current owner, or the seller, donor. Now, and then we have the grantee, who's the buyer or the recipient of that property. The way we're going to do this is I'm going to help you with some mnemonics. And if you don't know what a mnemonic is, well, you might have bigger problems. Now, some laws I know you all are going to encounter. Landlord-tenant laws. Landlord-tenant laws. Because we can't all own a property. It'd be nice, but we can't. We just aren't paid enough. And some of us have more important property to purchase than land. So for those of us in that case, we become tenants. Doesn't that just sound horrible? It is. Anyway, so landlord-tenant law. Landlord-tenant law. Now, this relationship is formed based on a leasehold. Now, there's 4 types of leaseholds. You have a tenancy for years, a periodic tenancy, a tenancy at will, and a tenancy at sufferance. That's a lie. And they sound all the same. So first, we're going to talk about the tenancy for years. Now, a tenancy for years lasts for a fixed amount of time. So your month-to-month lease is not a tenancy for years, even if you've been there 4 years. A tenancy for years is like, hey, Barbara, you're going to rent me this apartment for 6 years and not another day longer. And then Barbara says, sure! You're going to pay me $2,000 a month for 6 years. And voila, you have a tenancy for years. Provided you put it in writing. Because the statute of frauds, which we will get to when we get to contracts. Stop getting impatient. I will explain these things. I will drag you through every portion. Statute of frauds applies for anything that goes for more than 1 year. So, for it to be the requirements of it in writing, you have to identify the parties. You got to know everybody in the contract, right? Yeah. It identifies the property that's being rented. You want to know what place you're paying money for, don't you? It specifies the duration. We are talking about a tenancy for years, so in this case it'd be 6 years. It states the rent to be paid. You gotta know how much you're paying in writing. And it has to be signed by the party to be charged. In other words, you gotta sign the lease. Now, you also have to have the determination of time period. What happens if you don't comply? What the termination involves, what do you do at the end? What do you need to do if you want to end it before then? Those are important things to know. You got to know how to end something as well as create it. We're going to talk about periodic tenancy, which is going to be something everyone's familiar with because that's your month-to-month lease. Now, the terms of your lease may say a year, but it's still periodic tenancy because it's a repetitive period of time, meaning it is also ongoing. And it's for a set period of time until it is terminated by proper notice. Now, the term of periodic tenancy might be fixed. Now, the periodic tenancy can also be created both by an express agreement or by implication. So, if you have a tenancy for years and you decide to just stay and keep paying rent and they accept it, you've shifted from a tenancy for years to a periodic tenancy. Now, if you need to terminate that, because it automatically renews, notice is generally required to terminate it. That's the problem with automatic renewals. You have to actually end it. Now, generally, the lease will have the timing requirement and the writing requirement. And further include other ways it can be terminated, including failure to, follow certain rules. These are all things you agree to when you sign it. Next, we have a tenancy at will. Why are we having Will be a tenant? I thought he lived with Grace. Did he finally marry Jack? Oh, different will, okay. Tenancy at will. A tenancy at will is a leasehold that does not have a specific term. And it just kind of goes on and on, because it's the lease that never ends. It goes on and on, my friend. It's the tenancy at will. Anyway. So let's talk about creation. A tenancy at will can be created by the express agreement of the parties or by implication if the owner permits the tenant to occupy the premises. Now, let's say my lease has expired and I'm negotiating, because I'm good at negotiating. Well, until the landlord accepts, the payment of rent, tenancy at will is going to continue until that point where it transfers into a periodic tenancy, if we don't come to an agreement that makes it stay a tenancy at will. Now, a tenancy at will can be terminated by either the landlord or the tenant. Either one can end it. Now, you may see some provisions that say only the landlord may terminate. Well, in that case, you just got a picture. There's some invisible ink written right there. That, goes whoop whoop. Or tenant may end this lease. Now, there's got to be notice. And even if it says there's only the right of only one party to terminate, it is both. Unwritten rule. Do you think they'd just write it down? Finally, we have tenancy at sufferance. Sufferance succotash. And this exists after the period the lease has expired. So tenant remains on the property without the permission of the landlord. Meaning, you just say, hey, I know I'm supposed to move out, but I decided not to. Now, the landlord accepts your rent payment and you decide that, okay, yeah, you can stay. It goes from a tenancy at sufferance back to a periodic tenancy. Now, the landlord, if you are a tenant at sufferance, can decide to evict you, release the property to you, or wait until you voluntarily vacate. We all know they're never going to choose that last one. It's not going to happen. Now let's discuss some duties. Because it's important to know what you are required to do. Duties. Horrible little things. A tenant has a contractual duty to pay rent. They also have a duty to avoid waste. Depending on your lease, you may have a contractual duty to repair. You could also have other duties. There are things you can negotiate, but some, like some of the duties duties that are owed to a landlord, cannot be negotiated, waived, or canceled. Now, your duty to pay rent. There are three main situations where that duty is suspended. The premises are destroyed. The landlord partially or completely evicts the tenant. Or the landlord materially breaches the lease. Now, how might they materially, breach the lease, you ask? Well, they could breach the implied warrant of habitability. They could violate your covenant of quiet enjoyment. Because, I need my beauty sleep. They could fail in their duty to repair. And the landlord also has the duty to mitigate. Alright, we're going to talk about the warranty of habitability first. Now, the warranty of habitability is implied in every residential lease. Now, notice I said residential lease. There is no warranty of habitability for a commercial lease because it's supposed to be a commercial property. You shouldn't be habiting commercial property. Now, what does that warranty of habitability mean? Well, it does not mean everything you hope and dream. I can tell you that. It does not mean everything you hope and dream. A warranty of habitability is reasonable, suitable for basic human needs, which means it's a low bar. It is a low bar. It's not as great as you might think. What on earth are your options if the landlord breaches this implied warranty of habitability? I mean, it's not habitable anymore. Well, the tenant may vacate the premises and terminate the lease. Now, the tenant is not required to vacate the premises. But I'm feeling most of them will, if they can. They can withhold or reduce the rent. Now, if the tenant chooses to withhold the rent, the tenant must first notify the landlord of the problem and give the landlord reasonable opportunity to correct the problem. This is only reasonable opportunity. And it's reasonable time to correct the problem, not start correcting. That's important. They can remedy the defect and offset the costs against the rent. You can use the breach of the implied warranty of habitability to also defend against evictions. So yes, if they haven't kept the premises habitable, it can prevent you from getting kicked out on what might be the better location, the street. But sometimes a roof is a roof. Now, the one you're more likely to come across more often is the covenant of quiet enjoyment. Because we need our beauty sleep. We need all the beauty sleep. Now, it's important to know every lease, commercial and residential, includes an implied covenant of quiet enjoyment. And what this means is it prevents the landlord from taking action or having somebody else that they can control taking action that makes the premise wholly or substantially unsuitable for their intended purpose. Now, this results in what's called a constructive eviction. So if I lock you off the property, that's an actual eviction. You have been removed from the property. But a constructive eviction, I make it feel like, oh well, I can't go on there anyway. I know I can physically do it, but it's not going to do me any good. It's not what I'm using it for. The implied covenant of quiet enjoyment is breached. So what is the tenant to do? Well, they've been they've been constructively evicted. So first, did the landlord cause this problem? Did the landlord cause the problem that made it unsuitable for the intended purposes? Did the tenant notify the landlord of the problem? Has the landlord not corrected the problem? And then, after a reasonable amount of time has passed, has the tenant vacated the premises? Have they left the property? If they haven't, well, they haven't been constructively evicted, have they? Okay. We've talked about, the duties. Yes, the duties. Let's talk about your assignments and subleases. The transferring of your interests for landlord-tenant. That's called an assignment or a sublease. Start with an assignment. An assignment is a complete transfer of the tenant's entire remaining term under the lease. That means they're giving away the whole kit and caboodle. Every right they have, well, they're giving it. They're assigning it to someone else. Now, what if the landlord has a term in that lease that says you can only assign with written consent of the landlord? Well, means you gotta ask the landlord, and sometimes they don't have to give a reason, or they don't have to give one that makes sense. Now, you can technically still do it against the lease, but then, that's a breach of the lease. It's up to a landlord if they want to allow the breach or not. Now, the landlord can collect the rent from the assignee, meaning the person you have assigned the lease to, or the original tenant, because they're still the privity of contract. And then you're like, wait a minute, why can they collect from the assignee then? Well, that's because there's a privity of estate, meaning because that person's actually there, they're in a privity of estate with the landlord. And because you've signed all of your interest over, that's how they got that. Now, what about a sublease? Now, the difference between a sublease and assignment is a sublease is a transfer with less than the entire remaining term. Now, in this case, the landlord can only, and I mean only, collect rent from the original tenant, because they only have privity of contract and estate with the original tenant. The subtenant, the person who signed the sublease, their only rental obligation is to the original tenant. It's important. Sublease, you pay the original tenant only. Assignment, you pay the landlord. As far as your obligations go. Now let's talk about terminating these lovely leases. You can terminate it by surrendering the property. So you surrender the property, terminates the lease agreement, and ends the landlord-tenant relationship. Now, when does this occur, you ask? Well, a tenant returns possession of the leased premises to the landlord before the expiration of the lease, and the landlord consents. Okay, that works. Next is abandonment. It's not just the cause of your daddy issues. Abandonment occurs when the tenant unilaterally returns possession of the leased premises before the lease expires without the landlord's consent. Now we have the duty to mitigate. Now, the majority rule, which is got to be the only one, the majority rule is the only one that the UBE is going to care about unless it tells you otherwise in the question. The landlord has a duty to mitigate damages if the tenant abandons the property or is evicted by making a reasonable effort to re-rent the property to another tenant. Now, the landlord is entitled to damages for the difference between the original rent and the rent received from the replacement tenant. Meaning, just because you were evicted does not mean you're off the hook. Alright, before we move on to some special problems, I do want to share with you one mnemonic that does apply to landlord-tenant law. It has to do with the duties required of a landlord. And that is that a landlord is always required to hear. So, what does that mean? A landlord's always required to hear. What are they hearing? Well, they're hearing your whimpers and cries of having to sit through this. Don't worry. I'll get you a nice biscuit. So, here's habitability, quiet enjoyment, assignability of the lease, good repair, and minimal security precautions. So those are the covenants a landlord is always going to hear. So habitability, quiet enjoyment, assignability, good repair, and minimal security precautions. So they got to make sure that the property is somewhat secure.